All right, it's about 2:01, so let's go ahead and get started, and we'll let folks join in, but we have a lot to cover, so I want to make sure we have a good enough amount of time. For everyone on, thanks for joining. This is just a reminder, we're using the Zoom webinar platform, so unlike a Zoom meeting, you won't be able to unmute yourself or your computer or turn on your video. The presentation will run about 45 to 50 minutes, and we will leave time for questions at the end. So do feel free to put those questions into the Q&A, and we will be monitoring those as well. So let's kick things off. So welcome to the Cookie Conundrum, navigating the latest trends in privacy litigation and FTC enforcement. I'll admit the title is slightly clickbait because it's not just about cookies, but there's a lot of litigation going on in the privacy space right now. Some of that is generated by cookies, some of that is generated by other technology, but I'm excited to unpack all of that with you. My name is Jessica Lee. I chair the Privacy, Security, and Data Innovations practice at Loeb. Many of you have probably seen me before, but I'm really excited here to bring this webinar to you with my partners, Chris and JD, and I'll turn it over to them to introduce themselves before we get started. So Chris, maybe I'll start with you.
Hello, everybody. My name is Chris Ott. As Jessica mentioned, I'm a data security and privacy litigator. So I live and breathe this stuff. Before I was in private practice, spent a long stint as a white-collar prosecutor, federal prosecutor in New York, and I was a stint as the head of state-sponsored hacking investigations for the Department of Justice. So all that stuff together, I unfortunately live for this stuff. And so with that said, JD.
Thanks, Chris, and thanks, Jessica, for inviting me to be part of this. JD Taliaferro. I'm a partner in Loeb and Loeb's litigation group, and I have a consumer protection practice, both in the litigation context and with a heavy emphasis on FTC-facing regulatory matters and practice in front of the FTC.
Right, so you can see we brought the heavy hitters to go through these issues today. So let's go ahead and get started. Typical disclaimers. So first, I'm just going to set some initial stage about how we got here, what we're seeing, and I'm going to turn it over to JD and to Chris to get into the weeds. So we'll first start with the trends in class action complaints and some of the strategies we're seeing and successful responses. We'll also go into the trends in FTC enforcement, which JD will lead us through, and talk about, what to do if you get the FTC CID. What's the best strategy to position yourself for a response? And then like I said, we'll end with time for questions. So let's get started. How did we get here? What we're seeing, and this is not just this year, I think it's been building up over the last year, maybe year and a half. But there are some new legal theories that are being pushed forward, particularly by the plaintiffs bar and somewhat actually by the FTC as well. But to start with the plaintiffs bar, they're bringing lawsuits under a variety of laws, and they're testing the use of session replay, cookies, and other trackers on websites. And one of the avenues of attack is alleging that the use of cookies and trackers on websites is wiretapping, so that when you are using particularly session replay cookies, which track your movements across a website. They might track whether you enter information into a form, collecting keystroke information and that sort of thing. Typically, they're used on a website for fairly innocuous purposes, right? They could be used for heat mapping to see where people are spending time on the site. You might use it actually for compliance purposes to understand, did someone check the box and agree to get the text messages or consent? Sorry, this is my dog. Is very excited about this. So did any of that happen? Like, that's typically what a session replay cookie is for, and it doesn't really get the contents of communication necessarily, but that's the argument that's being led, that it's, and particularly in a state that requires two-party consent, that the use of those session replay cookies could be considered wiretapping. There's also a thread we're seeing under HIPAA where companies are alleging, we're seeing this both from private side, but also from the FTC, that the use of certain trackers on healthcare sites collecting health information, and that's violating HIPAA. And then finally on the VPPA, the Video Privacy Protection Act, there have been claims alleged that act is being violated, and some new legal theories being advanced there as well. So let me just give a quick word on the VPPA. Based on the RSVP list, I think many on the call are familiar with this law, but just to take a step back, this was a law that was previously enacted. I want to think it was 1988. This is coming out of when Judge Robert Bork was being put up for a Supreme Court position, and his video rental history at a movie rental store had been unveiled. And of course, when it happens to, a Supreme Court justice, people get concerned, and the law was passed to give privacy protection to your video rental records, right? So back then we were talking about like Blockbuster video type of rental records. But the law has been modernized by both the courts and also by some amendments to bring it up to speed to what we're seeing today, which is mostly videos are being delivered via a streaming platform. And so the question of what is personal information under those laws have expanded. But at its core, it still applies to videotape service providers that disclose personal information of a consumer. That consumer typically has to be a subscriber of that site. And it prohibits, unauthorized disclosure of that information in connection with the videos watched, consumed, or downloaded. And this is a favorite of the plaintiff's bar because it has its private right of action. And so what we're seeing now are allegations basically that any video on the site, someone told me that a diversity video on the site triggered a claim of under VPPA because there was a tracker running in that video. And obviously, I would make the argument, and I think my colleagues would make the argument that that's not what this law was intended. The individual there is not a subscriber. The company is likely not a videotape service provider, not in the business of providing this content. And then you can kind of go down the flow. And these are just some of the questions that you have to ask. And we're starting to see some favorable decisions in this regard. I know there was a decision in favor of Scripps at the end of the month, last month. That case came out of a claim that plaintiffs that had subscribed to free newsletters when they were watching HDTV were subscribers, and that HDTV had disclosed their online video viewing history information to Facebook because the Facebook pixel was running on the page. And the court there found that subscribing to the newsletters, which was a separate product, separate from purchasing or renting or watching any audiovisual content, did not make those plaintiffs consumers of content under the VPPA. So again, we're seeing this kind of stretch of some of these definitions. What exactly is just having any video content make you a videotape service provider? Arguably no. Is just watching or subscribing to one product but not actually subscribing to a video service, does that make you a subscriber or consumer? Likely no. But this is just wanted to flag some examples of what we're seeing of the stretching of some of these definitions and the increased threat potentially of litigation here. As I mentioned earlier, we're also seeing this come from the FTC as well. So the FTC, is, many of you probably have observed, have taken a number of creative positions. This is a very aggressive FTC. And so in addition to, kind of their traditional enforcement action, they've also been expanding, some of the penalties that they're enacting, looking at things like disgorgement of data and deletion of algorithms. We're starting to see some of their actions get challenged. I know JD will talk about Kachava a little bit later. But another thing they're doing in terms of, and also trying to kind of expand their scope, is focusing on unfairness. I think, historically we think of the FTC and the claims, we think about the deceptive prong of the Section 5 authority, but they've also been focused on the unfairness prong as well, which has this balancing test between, what's the benefit to the business versus the likelihood of a substantial injury to the consumer. So again, I'm just setting the stage here for what we're seeing going on from both the class action side and the FTC regulatory side before Chris and JD jump into the weeds. But this is just some examples of what could be considered unfairness or what could be considered unfair. So Kachava, and again, I'll let JD get into the details, but that was about the use of location data and the likelihood that it could reveal sensitive location could lead to harm. I've also seen claims that, undisclosed secondary uses of personal information, also potentially unfair, lacks security practices and lack of transparency, also potential to be unfair. So I think we're seeing just a change in environment and expectations, and the FTC has been a little bit hamstrung, and I think they're trying to at least push forward their agenda. The idea is when you see enforcement action from the FTC, in addition to hearings and other position papers, you get a sense of what they would like to see from the market and where they want to go. And, they have this kind of carrot stick approach. We'll hang these things out here. We'll expect you to comply. And then if you don't, we're going to try to set a record so that we could engage in more heavier handed enforcement action. So with that kind of stage setting, let me hand it over to Chris to talk about challenging the class actions and what we're seeing in trends in terms of class action complaints.
All right. Thank you, Jessica. So where we're going to start focusing on is the top circle in the Venn diagram that Jessica gave us, the wiretapping. And what we've seen over the last few months is a real boom and bust. Maybe I'm overselling the bust, but a real cyclical action when it comes to wiretapping cases. And these things often do start with a single decision. So if we can go to the next slide, Jessica. All right. So first, a little background of what these wiretap claims are. Most of them are being predicated upon violations of the California Wiretap Act. That is the California Invasion of Privacy Act, the CIPA. That's the 630 et sec that's mentioned here. There are two theories under it that are being advanced by the plaintiff's attorneys. The first is that when you have a website with any kind of chat function, the recordation of that chat, that's being typed in by both parties, the fact that it's saved constitutes a primary wiretap by the actual owner of the website. That would be under 631A. The second is because almost every company that has a website is using a third-party technology for their chat functionality, that having that third party there, you, the website operator, are aiding and abetting the third-party wiretapping of the conversation. So the idea is, in the first place, just recording these chats constitute a wiretap. And in the second place, in fact, you're bringing a third party there. Even if you are not wiretapping us, you're helping somebody else wiretap us, whether it be the pixel or some other functionality from a third party. That's what's doing it. Sorry, Jessica, I jumped the gun there. All right. So how do these claims happen? So there'll be a demand letter of a few ingredients to it. Out of nowhere, you'll get this letter submitted to you or your client saying that, hey, I have a plaintiff. There'll be one person. This plaintiff utilized the chat functionality on your website. We looked a little closer under the hood with a right-click kind of forensics on your website, and we could see that the chat information is being transferred to a third party. From all that, we see that this is a violation of CIPA, and we are going to give you a one-time opportunity to pay us somewhere between $50,000 and $75,000 to go away. No promises that nobody else will bring the same claims. You'll get the chance, I guess, to fix this. Maybe we'll give you some guidance on how to do it. But just do us a favor and pay us the $50,000 to $75,000. That's what's going to be in that demand letter in broad terms. It'll be a little more than a page long, which means you've got about a half page of content after the headers and closing regards, etc. The content you get there is not a lot different than what you see arrayed on this slide. My client is X. There was this chat session. You are transferring data to a third party. This constitutes violations under the two main theories that the plaintiff's attorneys are using under the CIPA. We are going to bring a class action, pay us this money. So that's what's in that demand letter, and that's what you'll be faced with. Now, the decisional tree there can be kind of fraught. Well, how much is this worth? How strong is this claim? I mentioned that one decision can kind of drive a boom and a bust on this. Let's take a look at that. All right. So this is the bad one. Goodyear. This is not the Goodyear blimp on the right, but it gives you kind of the aura of disaster we've got here. The Byers versus Goodyear. There's the plaintiff. We can only see the litigation side of this, but I imagine it followed the demand letter cycle we just saw a moment ago. filed in the Central District of California, class action. There was a motion to dismiss that was decided on February 3rd, 2023. So very recent vintage. We're talking 3 months ago now. And the decision was decided by Judge Sykes, who's a relatively newly minted judge in the Central District of California. She denied the motion to dismiss. Now, in denying the motion to dismiss, Judge Sykes did not include a lot of reasoning, but that has its own weight because we know what she was presented with. She was presented with the theory that 631A, when you've got these session replay cookies broadly, or more specifically, these chat sessions, that is cognizable claim, at least for motion to dismiss terms, to say that the person or entity that has this website actually recording the chat sessions could constitute a wiretap under CIPA, that first section 631A. And second, that it could, by using third-party technology, constitute aiding and abetting third-party wiretapping of the same conversations. So again, she didn't get into the weeds in her reasoning, but the fact that it survived, it emboldened the plaintiff's attorneys quite a bit. And thereafter, anecdotally, and I imagine from an absolute sense, we saw a real boom in the number of these demand letters coming out. They followed the same anatomy as before, and they, without fail, cited this Byers versus Goodyear case and said, hey, by the way, you'd be lucky to pay us $75,000 because to litigate this is going to cost you hundreds of thousands more. This new disastrous paradigm didn't last long. Next slide, please, Jessica. Forgive the oblique Star Wars reference here, but in the Central District of California, that's February 14th decision. So we're talking 11 days later, Judge Bernal grants a motion to dismiss. And in granting the motion to dismiss, he did a number of things. The mere existence of granting a motion to dismiss means we've got probably directly opposite outcomes at this motion to dismiss stage, which improves the negotiating stance of anybody getting these demand letters. But we get into the details of Judge Bernal's decisions, because he actually issued a number of them in cases. Things get better. Actually, can we go to the next slide, Jessica? All right. So first, 631, that first theory we were talking about. Judge Bernal says, no, you can't do a wiretap. You're not wiretapping if you are the party to whom you're talking. That's primary party exception exists under federal law, and by the way, exists under the CIPA. If you mean to chat with people and you're typing in information and they record what you type in and give to them, that's not a wiretap. So no go on that theory. Next, aiding and abetting a third party interception. If they're just using the technology to do what we just described in 631A, that is not aiding and abetting third party the transcription. It is, I believe Judge Bernal used the example, if you record somebody with knowledge using a tape recorder, the manufacturer of the tape recorder is not doing a wiretap. They are recording the information for the primary party. And that's the same situation we have here. Judge Bernal then spent a long period of time hammering the plaintiff's attorney. You'll notice Byers is the repeating plaintiff's name here. It's the same attorney for both of these cases. And I believe he cites dozens of cases filed by the same plaintiff's attorney over the preceding weeks, and says they're all cookie cutter allegations with no investigation, due diligence, and should all be dismissed. He also takes the time to note, yes, and I am aware of the Goodyear decision, another district court decision here from February 3rd. And although district court decisions can be persuasive upon another district court judge, they're only persuasive to the extent that they are persuasively reasoned, which in federal judge speak counts as a sick burn, because Judge Bernal said that he was not well reasoned and he would not follow it in any way. I mentioned they issued decisions. There are a number of these decisions reiterating almost verbatim the complaint, the reasoning of 631A out, 632 out, and plaintiff's attorney get out of here. You're wasting all of our time. So at a minimum, you have these competing lines of reasoning in the Central District of California. What's gaining traction? We are now February 14th. People are almost all taking Judge Bernal's side in this little tiff. Central District of California, we have Judge Fitzgerald deciding 2 cases, adopting nearly verbatim Judge Bernal's reasoning. You'll notice again the repeating plaintiffs, because it's the same person over and over again for these plaintiffs' attorneys. Lycia. There were probably a dozen Lycia cases under the same theory filed. Northern District of California Judge Alsop, Sparza versus Lennox, nearly identical reasoning, dismissing these. Eastern District of California, there's the magistrate judge issues a report and recommendation on a motion to dismiss, again adopting the same reasoning. All this says, although you're getting these demand letters, maybe we should greatly discount the value of what these claims are. Maybe $50,000 to $75,000 is enough. And they would say, yeah, yes, but what if you get Judge Sykes? Well, there's actually an answer to that too. This, by the way, these decisions are all coming out between February 14th and April. So we're about 2 months with a half dozen of these. Remember I noted Lycia. Well, here's another one of those Lycia cases here, but it's with Judge Sykes again. And she dismissed the 631A claim, saying, yeah, it can't be a wiretap. You'll notice that's different from the first buyer's decision, because she's a federal judge. She doesn't have to admit she was wrong about anything, and she uses that to not admit she was wrong about anything. And in the second theory, the third party aiding and abetting claim, she largely punts on that. I say largely. She says, as alleged, this cannot be third party aiding and abetting, but they'll give you another chance to amend to articulate why it is and give some hope for it. But again, that decision's gone. And every time you wipe these claims off the table, it's added costs for the plaintiff's bar shakedown artists that makes their decisional calculus that much harder and puts people like our clients in a better position. So let's take a look at the next slide here. So this is the timeline I was talking about. We've got action-packed 2 months here. Oh, sorry, I misspelled February there in the beginning. But all the way in the course of about 2 months, we have even Judge Sykes coming around to the main reasoning that these decisions, these theories should not prevail. That's not to say there isn't cost and that there aren't things that have to be done, either to prophylactically prevent these letters from coming in or to respond strongly. Anecdotally, I can tell you that we have been responding strongly back to these letters. They say, $75,000, and you can say, thank you for paying that. And our response has sometimes been along the way, how about nothing and you don't talk to me again? And negotiations go on from there, but that's a stronger position to be in. Although it can be, again, we talk about action-packed, those are action-packed negotiations too. So that's the arc of what we're seeing here. It's evolving like most things in this space are. I mentioned I do data security and privacy litigation. The theories are new, the norms and allocation of risk are new, and there's froth on these things. But it's interesting to see where we can see real development and advantages growing over time. Here we've got a timeline of 2 months, and the arc is becoming very clear. Next slide, although we may be done. All right, no. So with the bad federal law, we're seeing some pivots by the plaintiff's attorneys. They are either expressly or tacitly saying, well, we're not going to start out by filing these cases federally. The thinking there is they're less likely to get a motion to dismiss granted in front of, say, LA Superior Court than the Central District of California. Just from that roster of cases, you could see a vast percentage of the active judges on the docket in the Central District of California have already started dismissing these cases. So they'd rather be in front of an LA County Superior Court judge. Also, culturally in California Superior Court, the judges are less willing to dismiss cases at the pleading stage. So you can get stuck there for a while. But how could it be in state court if it's this class action? It's not a class action. It's an individual claim. So the downside for them is the value of their claim is the statutory damages that Jessica was talking about. That's $5,000. The class action is not there, and once it is there, it's arguably removable. They are focusing more on the third-party wiretapper allegations, the second theory I was talking about before, and trying to articulate how whatever cookie is being used, Salesforce and their functionality for this ends up getting mentioned a lot, and how that third party is then utilizing the intercepted information. There's going to be some more litigation on that second theory. That door's open a little bit, but things are improved. And as to the last point here, they're internalizing defeat. They're pricing in the fact that these are not as good a cases as they were hoping they were on February 3rd. And in real time, we're seeing that in negotiations. And we'll see what they do. Jessica, let's just see if I have another slide. Nope, it's now JD's turn.
Thanks, Chris. Yeah, so I mean, obviously a lot going on, but at least a positive trend. The one thing I will say, at least, excuse me, what I've seen over time is once this dies down and they've sort of squeezed the juice out of this one, they'll look for the next thing, right? So we always have to be on our toes, but it's good to know that at least some common sense interpretation of these laws will prevail. So with that, let me turn it over to JD to walk us through the trends in FTC enforcement, because if it's not enough to deal with the class action bar, we also have a lot of threats coming from the FTC.
And Jessica, I just wanted to say, I felt your comment that this is a FTC with an expansive view, because it was hard to even do these slides because every day I did a draft and then something else would drop. But in the next 12 to 15 minutes, I want to go through three things with you. First, I want to talk about areas of FTC focus, enforcement focus. I want to give you some practical discussion of what to do if you receive a civil investigative demand, which is the FTC's primary investigation authority. And then I want to end with a lightning round of takeaways from three recent FTC actions. Two of them at the FTC level, and then one of which actually made its way in district court. So first of all, the pace of privacy cases has more than doubled from 2022. I think that we now are up to 7 or maybe even 8 in the last couple of days in 2023, compared to 6 reported cases in all of 2022. So you can see that the pace is ramping up. The 2 commissioners have departed in the last 6 months, leaving only 3 commissioners. And the 3 commissioners that are on have a similar viewpoint about the expansion of FTC's authority, and it's kind of let them or given them the opportunity to engage in some of their more novel theories of enforcement. The FTC has articulated a number of reports to show the things that they're focusing on. And there are things that you're all familiar with, but things like health apps, the accuracy of data for housing, employment, and credit, video conferencing coming out of COVID is obviously an area of focus for them. Educational technology, particularly as it relates to children's educational technology and the enhanced risk that the FTC sees around the privacy concerns of minors. And then finally, data and technology that can exacerbate racial disparities. And let me just talk to AI for just a moment. The FTC has issued particular concern about AI in the following sense, that if the underlying data set that your AI model is built on is in self has bias and discrimination baked into it, then the AI model carries with it that same risk. And let me give you a practical example of this. If you take a loan approval data set and use it to build an AI model that automates underwriting standards, and there are racial biases or gender biases baked into the original set of loan approvals, the FTC's view is that bias makes its way into the AI model. And so there's a risk when you choose base data sets that you have to make sure that your data sets are themselves free of underlying bias. I want to talk about two proposed rules. One is the proposed amendments to the health breach notification rule. This is a rule that's been on the books for a couple of years, but it was largely viewed as dormant. There weren't a lot of enforcement actions, but in the wake of obviously some concerns about legal changes in the United States, this rule has come back with a vengeance. It's an area of enhanced enforcement focus, and there's some amendments that have been proposed to it. The biggest one is it clarifies that it extends to apps and technologies not covered by HIPAA. So you could have information that is probably excluded by HIPAA, but is nevertheless going to be captured within the scope of the health breach notification rule. Secondly is the breach of security definition under the HB&R. Extends not only to data security breaches in a more traditional sense, but also unauthorized disclosures. And then finally, it increases the amount of information that you have to provide to consumers when notifying them of a breach. You have to notify them of potential harm that could arise out of the breach. And then you also have to provide them with the names of any third parties who might have acquired the unsecured health information. This is a trend we're going to talk about again at the back end, but the FTC is increasingly concerned not just about what you as a holder of private information of personal data have done, but the potential that you have or that you've created to have shared that with third parties. And those are all things that are in the proposed amendments. We expect that those amendments will largely be adopted as proposed. Okay, let's go on to the next slide, Jessica. So the big thing that's coming down the pike is the proposed rule on commercial surveillance and data security. There was a ANPR period, general comment period last fall. Comments closed with thousands of comments on the rule. But you can just get a sense of what the FTC is after. And this would be the first broad-based data security rule that the FTC has ever adopted. But it uses terms like harmful commercial surveillance, persistent tracking, extensive tracking, surreptitious tracking, granular data that tracks children, and lacks data security practices by firms. And this is the headline description. This is how the thing opens. Firms now collect personal data on individuals on a massive scale and in a stunning array of contexts. The ANPR asked 95 detailed questions, and you can kind of get a sense of where the rule is going to go based on the questions. There's, I think, some built-in assumptions that are going to be in the rule when it comes out. But the FTC clearly is itching to deal with data collection and monetization of that data collection, and then also enhanced data security requirements. They're also going to pretty clearly broaden the definition or the protection of the rule, not just to customers or consumers, but it's also going to be expanded to employees as well. The next step in the ANPR process is going to be to for the FTC to synthesize these comments into a proposed rule. Then there'll be another comment period and a hearing before the rule is finally adopted. Reading the tea leaves on the timeline for this is, of course, a favorite Washington pastime. But I anticipate that you're going to see the NPR sometime this summer or fall. I think the current makeup of the 3.0 Commission is going to try to move while they still have a big advantage. And I would expect that that's going to be sometime in the fall. Let's see. Do we have the CID process slides, Jessica?
Those are after. Do you want me to
Oh,
skip
okay.
ahead?
You're trading up a little bit on me. I'm happy to do
That's fine.
that. Okay. So let me talk about the three cases that I wanted to talk about. Kochava is obviously of importance. For right now, Jessica already articulated the standard of law. The FTC needs to show substantial injury to consumers, and they need to show that it's not outweighed by the countervailing benefit to consumers. Here's the key holding that's been in the last week or two from a district court out in Idaho. That first of all, that geolocation data by itself is not enough to constitute substantial injury. The FTC's case was really built around the so-called sensitive location argument. And the judge found that just the data itself was not enough to constitute a substantial injury. And the sensitive location argument was kind of a derivative argument because it relied on a bad actor. And of course, the unsaid bad actor here is a potentially a state regulator, state government of kinds. But the judge held that that threat was secondary and only a mere possibility, that it didn't actually have any demonstrated effect at this time. And this is what he said about geolocation data. I thought it was pithy but good. Geolocation data showing that a person had visited an oncology clinic could reveal that the user suffers from cancer, or it could reveal that they have a friend or family member that suffers from cancer, or it could mean that they're a pharmacist or is in the business of selling medical devices. The FTC does not actually claim that Kochava is disclosing private information, but rather that it's selling information from which private information might be inferred. Now, the next act in this is that FTC has been given leave to amend their complaint. I think that they're going to have a hard time based on the first ruling to amend to show substantial injury, but I expect they'll give it a shot. I'm expecting the same result from the judge, but he's at least given them a chance to amend their complaint to try to allege substantial injury. The second case I wanted to talk about is the pre-mom fertility and pregnancy app. The key holding here, the thing to take away from this is that even if pre-mom itself did not have invasive matching data or customer identification data, they shared with software development kits, so-called SDKs, that did have the ability to identify users. And the example that is given in the description and in the charging papers is that, for example, Company one could share with an SDK an advertising ID and an IMEI, which is a unique ID associated with the cell phone. Later, a third party could receive information that that same IMEI number used a different app. And then sometime later, that same third party could learn that the same advertising ID is associated with the IMEI. So in other words, you have the advertising ID with party one, you have the IMEI with party two, then you have party three that has both of those things, and the sum total, of course, adds up to giving someone the ability to identify the person with particularity. And so the takeaway on that case is you need to be thinking not only about what you have and what you're sharing, but what the third parties with whom you are sharing may be gleaning from other third parties. And it really creates, I think the term Jessica used was secondary effect, but this is a perfect example of how the secondary information effect can add up to an identification. And this is an area of real concern for the FTC. And then the third case I wanted to talk about, GoodRx, and this is a hugely popular app. I've used it myself, and I probably should have thought a little harder about what personal information I was giving up. It has 55 million customers in the United States. It's used to get discounts on prescription medicine. And I want to go one more slide because I think the key here, or not one more slide, I meant one more bullet point. The key here is that one of the violations of the FTC Act was that GoodRx was targeting its own users through the Facebook platform with medical and health-related advertisements. So in other words, you've opted into GoodRx's privacy regime. They know that you're a Facebook user, and you've probably seen ads like this, but we haven't seen you in a while, or come back to us, or here's a reminder about GoodRx running on Facebook. And that's also true of the BetterHelp consent decree, which is another health-related issue. And so the takeaway from those cases is that even if you're sharing with a third party for the purposes of outreach or targeting to your own customers who've already consented to and opted into your privacy policies, the FTC is going to take the position without adequate disclosure that sharing across to an advertising platform, and it's probably same thing is probably true of other advertising mediums, is going to be an FTC violation without clear informed consent by consumers that they're consenting to that kind of thing. And here you had the opposite. You had GoodRx pretty clearly saying we're not sharing your personal health information, but for example, in the case of BetterHelp, we haven't seen you for a counseling session in a while. Like, here's 20% off of your next session is viewed as pretty clearly sharing of health information outside of the consumer's consent. So let's talk about in our last 5 minutes or so what you should do when you get a civil investigative demand. A civil investigative demand is usually your first indication that the FTC is reviewing your business practices. But at the same time, it's likely that staff has already either received a complaint, or they've been using public resources, or they've been doing some sort of private investigation before you get a CID. So there's two things to remember about CID. One, don't panic. Many companies receive them, answer them, and they receive a closeout letter without penalty or consent decree. But conversely, you need to do whatever is just a few steps below panic. You need immediate attention. I've seen situations where this thing bounces around internally for 3 to 5 days from inbox to inbox, and you really need to jump on these immediately. And your stand-up team, the team that you put together in response to that, needs to have not only legal and privacy people, but you need to have your IT people on a data breach or privacy CID from the start. Those are things that need to be done as soon as you receive it and realize that you have it. The CID is going to have an elements, a nature and scope aspect to it. That'll give you a little bit of information about what the supposed violation is. This is from the Wyndham data breach, and it'll tell you that there in the third line, you'll see this is data privacy and data security CID, and it'll give you an idea of what the FTC is going after. and what the point of the investigation is. You need to pay attention to the time period of the CID. You don't need to look for documents from time immemorial, but you do need to note what the start period is and what the end period is. It usually runs through the full answer, and then the time period has usually a 5-year look back period is pretty typical. You need to look at the nature of let's go back one, Jessica. Thanks. Sorry. You need to look at the requests. Sometimes the requests are going to say documents sufficient to answer the request. Sometimes they're going to say all documents. If you've got all documents, you've got the trip to the warehouse or the trip to the data archives. But if you have a document sufficient to, you can usually pick and choose, and you have a less exhaustive response. And then the response date is usually on the first page of the CID, and the response date is 30 days, really tight timeline, 30 days from the time that the CID is issued. One of the reasons you need to jump on the timeline and get involved right away is because you have two really important deadlines to start with. One is the meet and confer deadline. It was 10 days, as this case here. This has now been extended to 14 days, but you have 2 weeks to meet with the assigned staff attorney at the FTC. And the meet and confer time is important for 2 reasons. One, it's your best chance to informally address overbroad and burdensome responses. And then secondly, if you're going to do a rolling production, or you're going to kick out the 30-day time frame, the best chance to get that done is at the meet and confer. So you can understand which of the requests are most important to the staff, and which you can have a little more time to work on. If there's not some national emergency or immediately pressing thing that staff is after, my experience is they've been very willing to work with you on rolling productions and extension of some of the deadlines. The second thing that you need to jump on is a petition to quash or to limit, and that would be a more formal proceeding. You would file that petition with the FTC. It would be heard and resolved in a more formal manner, and you can do that if you feel like you're not getting any traction with your meet and confer process. The trade-off on a petition, there's 2 trade-offs. One is it's the FTC that's making the ruling on whether to quash its own subpoena. So you face not great odds on getting that to happen. And the second thing is, if it's an area of sensitivity, or it's something that, if you're a publicly traded company you're dealing with, is a matter of sensitivity, filing the petition makes your CID public, because you're filing that on a public docket. So I just wanted to give you a taste. I mean, these things are quite exhaustive. They can run into the dozens or 50 more, but this again is from the old Wyndham data breach, one of the first data breach CIDs that FTC did. And you can see that the answer is requiring a detailed network description of computers, servers, firewalls, routers, VPNs, remote access network, websites, and intrusion detection systems. So they're going to require a lot of effort and work to get the CID together. If it's, for example, if it's related to data sharing or third-party sharing, you're going to anticipate pretty detailed IMEI questions, MAC questions, circumstances under which geolocating data could result in identifying of a customer. And the response is going to take a significant amount of time to get together. So that's another reason why you want to jump on this early. You want to stand up your team, and you want to make sure that you're working towards getting answers together. CIDs typically require the filing of a written report. And I'll say two things about that. One, this is not an opportunity for spin or for manipulating your response in a way that the FTC views as less than fulsome. But at the same time, it is and can be an advocacy piece, particularly if you can provide background color. Experienced attorneys can help you craft responses that fully answer the question, but also appropriately provide color and background that helps the FTC understand exactly what has happened in your particular circumstance. Is that the last one, or was there another slide?
Nope, I think that's the last
Okay,
one.
great, perfect.
Thank you. And I know we have a couple of questions that came into the chat. Okay, looks like Chris, you got some of these already. Got it. Okay. So I'll stop sharing my screen so we can see our faces. Yeah, so I think we covered a lot today. I want to thank JD and Chris for going through all of that with us. If you have additional questions and you want to drop it in the chat, we have a couple of minutes left. I do have one question maybe for the both of you, which is, considering post-Kachava, do you think we'll see more companies challenging the FTC and their authority? I think leading up to this, you would have heard rumbles of companies wishing someone would challenge, because there was a thought that, that it was at least vulnerable to challenge if it went to court, but no one really willing to do that. So I'm wondering if you think we'll see a trend in that direction for companies on the line who think they might be getting, an enforcement action or getting a position taken by the FTC that goes beyond their authority.
I think you absolutely will, given the current commission makeup, because I think people feel like companies feel like they aren't going to win in the negotiation process. They're just not going to get the kind of trade-offs that they would get in if it was a negotiated consent decree. They're just not going to get the kind of concessions that they would have gotten before. Now, I will say, just as a stickler for civil procedure, Kachava's lawsuit against the FTC was in fact thrown out of court. And so the value of them suing first was not legal, but it was, it was definitely some hardball litigation tactics where they just decided they weren't going to wait for FTC to file. They sued first, and the cases were related, so that they got assigned to the same judge. I mean, formally he threw out Kachava's lawsuit, but I think it probably had the effect of making him stand up and take notice when the FTC's lawsuit came back on the heels of that there was something maybe a little out of the ordinary that it should take advantage of. So in the current FTC environment, you're absolutely going to see more companies doing that.
In a broader kind of legal context, JD was using a lot of the Wyndham FTC stuff there. As I recall, there was a legal challenge to the FTC that Wyndham ended up doing. I could see a similar one mounted again now. That would be more successful because the appellate courts and the Supreme Court are a lot more hostile to the expansive powers the FTC is asserting these things. Now, whether that means the companies are willing to take on the cost of winning, it's a separate issue, but the opportunity is probably there.
Interesting. And then maybe for Chris on the litigation side, are you seeing any of the you mentioned like prophylactic measures that a company might be able to take to push off some of these claims? I've been hesitant to advise to make too many changes for what I think are frivolous suits, also keeping in mind that once you do one thing, the plaintiff's bar will find something else to bug you about. But have you seen any of those prophylactic measures be successful, and are you advising anything?
mean, it's tough to say how they're successful, right? Because if they're successful, you wouldn't get a letter. All right. So, right. I mean, from the way they're phrasing their complaints, the problem has to do with the consent. So if they're being intellectually rigorous on this, if you were getting consent at every step along the way for something that's being recorded or transmitted, then that should be effective. Something that I think people are working on, even with your more cautious advice, is trying to build things into the privacy policy itself on the websites that could have some effects. It may not get you to win right off the bat, but it's going to be strong evidence if you built in, hey, these are among the things you're consenting to here under the hood. Those are the things I hear people talking about dealing with, but also with the current trend of cases, a lot of people are saying, let's fight it out. Yeah, let's not do anything.
Well, and maybe before we wrap up, it'd be helpful to hear from both of you what you're looking out for on the horizon. I mean, maybe that answer is too easy for JD, since every single day there's a new FTC enforcement. And I think we see the trends. It's clearly a focus around health information and location information right now. I think we'll still see more around children. And I think AI and discrimination, like you mentioned, is top on the list. So I expect we'll see some actions coming there. But, what are you bracing yourself for in the next, call it like 6 months to a year?
Yeah, I think it's going to be the commercial surveillance rule and how quickly that rushes out. And the reality is, I think that's headed for litigation, regardless of how broad it is, because there'll be a challenge to it being outside of Section 5 authority. But that's definitely going to be the area of focus. There's a off chance you could see some hill movement on the data privacy law, but I suspect that's just going to be bogged down in the 2024 election and general Washington inertia. But I think the proposed rule is going to be the big thing.
I have to raise my hand to say, sorry, Chris, I was going to say, I have to raise my hand to say, I think zero chance on a federal privacy bill, at least for 2023. But,
I don't disagree.
Wrong. Go ahead, Chris.
Oh, yeah, I was going to say, in the short term, there's going to be some procedural fighting in these SEPA cases and things like them, because they've made this pivot to the state courts. And there's going to be a fight to remove them either to arbitration or to federal court. I've got some tactics and strategies on how to make that work from the defense side, but they'll be fighting back.
Well, thank you both so much. We have probably 30 seconds to spare. So for people who need to jump to their next call, we can give you that time. We thank you for joining us. We'll circulate the deck and this recording after the fact. But again, it's really exciting to have our litigation team here to brief us on these issues, and we'll continue to keep you posted. So thanks all. Thanks, Chris and JD.
Thanks, Jessica.
Bye everyone.
Bye-bye.